Recording in progress.
Hi everyone, and welcome to another installment of my Living Trust Wills and Powers of Attorney series. This is a repeat of some previous ones that I've done, and so if anyone's tuned in before, you're going to be hearing a lot of the same information that I've talked about before, but it's always good for a refresher, and welcome to anyone who's new who's tuning in. And today we actually do also have a hybrid model where we have a guest in the studio with us today, as well as people who are tuning in by Zoom. So for future presentations, we'll also be doing a hybrid model as much as possible. So just to introduce myself, my name is Alyssa Chow. I'm an attorney here in the Sacramento area. I did grow up in the Greenhaven Pocket area. I went to McClatchy High School, and I have had quite a bit of experience in volunteering with ACC in the past, just growing up, and then since returning back from school. I also am the Vice President and Secretary of the Sacramento Asian Sports Foundation. And as is a requirement for every presentation that I give here, I always have to give a shout out to my mom, Sue Chow. She's a pickleball player, and you may have actually seen her if you tuned in for the ACC pickleball tournament last week. I don't know how well she did, but I'm sure she killed it. At any rate, so today we're just going to get started with talking about living trusts, wills, and durable powers of attorney for both finances and healthcare. So I always like to start off my presentations with a question of, what really is estate planning? I think a lot of people probably don't realize that they've already been doing some form of informal estate planning, typically in the form of either doing beneficiary designations for certain accounts, kind of like if you've got just your regular bank accounts or investment accounts, and then also retirement accounts, really common that You may have beneficiaries designated for that, and that's an informal method of estate planning. Another method is by taking title to property, whether that's having joint accounts with other people or even taking title to real estate with someone else. The way that you take title really matters and ultimately affects the ultimate plan for what happens to those assets. And so we can talk a little bit more about that later. Primarily, though, what I do want to focus on for today are all of the different legal documents that are typically going to be considered more of your formal estate planning. And what we'll be going over today is a revocable living trust, last will and testament, durable power of attorney for finances and other personal affairs, and also your advanced healthcare directive. So first off, what is a revocable living trust? Well, in the name itself, it is revocable in the sense that any of the terms that you put into what is otherwise just a legal contract, any of those terms that you put in can be revoked or amended over time. And depending on whether you create that trust yourself as an individual or you create it with someone else, there's lots of different ways that we can structure it for you as far as the amount of control that you as the person who's creating the trust will have over that trust itself. This is to be distinguished from an irrevocable trust, which you may have also heard of. Typically, people will do irrevocable trusts for very specific reasons, normally either because they are really at risk of having to pay the estate tax, which is very high right now. The threshold for potentially needing to pay estate taxes, I should say, is very high right now. And another reason would be potentially for making sure that you can qualify for public benefits. So some people like the idea of an irrevocable trust, but you do lose on that flexibility of being able to make changes to that trust if you decide to do it that way. So for the purposes of today and for most people, I'll be talking about a revocable living trust just because it is something that over time can be adjusted if there's changes in the family or changes in assets that might warrant an adjustment to how you have assets that are going to be ultimately distributed. So like it says on the slide, a revocable living trust is basically just a legal contract, and it's going to provide instructions for control, management, and ultimately distribution of assets. You as the person who's creating the trust, you're going to be the most important person as it relates to the trust. So during your lifetime, you would be the one who's in control, you're managing all of the assets, and you're ultimately the one who's only benefiting from the assets during your lifetime, regardless of whether or not you yourself are in control. And really, when we talk about a living trust and what it actually is going to control, it's primarily going to be any assets that are actually what we call funded into the living trust. And really, the trust itself just serves as a legal key to give you or your successor trustees the ability to access those assets. And we'll talk a little bit more about that. So what does it actually mean to do proper trust funding? Like I mentioned, we might put together all these legal instructions about who's in control, how items should be managed, and after you pass, where those items should be distributed. But it doesn't do you a lot of good to put those instructions in place unless you actually have assets that are connected to the trust or that are formally controlled by the trust. And so we refer to that in the estate planning world as funding of the trust. And funding can take on a couple of different funding can be done in a couple different ways. So on the slide here, I've got some examples of assets that are only those types of assets that are actually considered properly funded into your living trust. And it's going to fall into one of two general categories. So the first one is assets that are actually titled in the name of the living trust. So for example, let's say I create a trust, right? And I do the Alyssa Chow Living Trust. And that's the name of my trust, okay? Now, if I have a piece of property for my house, I'm gonna wanna make sure that I actually prepare and record a transfer deed for that property so that it shows that the owner, instead of being me just in my individual capacity, it's actually in the name of my trust. And what that does is it creates a formal tie between all of the instructions that I put in place in the Alyssa Chow Revocable Living Trust or the Alyssa Chow Living Trust, and then that asset itself. So One of the biggest mistakes or errors that I see as an estate planning attorney when I meet with people who maybe did their trust 20 or 30 years ago is that they may have a list of assets that they intended to connect to their trust, but they never took that extra step to actually formally fund those assets into the trust. Some other examples of funding by titling would be if I retitle my bank accounts into the name of my trust, brokerage accounts or investments, or bonds, things like that. So those are all some pretty common examples. A lot of the times clients will ask me, well, do I have to go to the DMV and put my car into the name of the trust? And you don't necessarily have to do that unless you've got a really high value vehicle that's worth over $150,000 or something like that. But for the most part, vehicles are treated as if they're personal property, and that just gets pulled into the trust itself through an assignment. As far as the mechanics of why the funding really matters, I know I mentioned earlier that you're creating a legal tie, but what does that actually look like, and how does that actually play out in real life? So if we're going to talk about real estate, for example, like I said, if I had a piece of property that was just in my name, right, it just said Alyssa Chow and that's it on the title, if something happens to me, right, if I become incapacitated or if I were to pass away, nobody else is on title to that property, and so no one else has authority to do anything with that property. So if, let's say, I do pass away and my husband needs to do something with the trust, or needs to do something with that property, because it was only in my name, and even though we were married, he's going to have to go to court in order to get legal authority to do anything with that house. Normally we would look at it from the perspective of like a title company, right? So if he went and he listed the house and he tried to sell the house, the title company would look at that and say, well, it looks like Alyssa Chow is the owner, where is she? And he would say, well, unfortunately she's passed. And they would say, well, we don't see any legal documents here that are connected to this property that show that you have authority to sell or even list to this property, and so we need you to go get a court order showing that you have authority to actually sell the property or list it. Now, on the flip side, if the house was titled in the name of the Alyssa Chow Living Trust and I were to pass away, assuming that I name my husband as the successor trustee of the trust, all he has to do is make sure that as long as I had the house titled in the name of my trust, he just needs to present a death certificate and basically do what's called an affidavit death of trustee to put himself on title as the successor trustee with the authority to manage, sell, do whatever he needs to do with that property. From a title company's perspective, they would look at that and say, okay, we feel comfortable now because there are legal documents in place that were already established before Alyssa passed away, and now we feel comfortable with you listing and selling this property. So that's how we really want to make sure that we're getting around dealing with any court requirement for someone to be appointed. And we'll talk about the court system a little bit more later, but that's just one example. Sometimes when it comes to married couples, you might take title together, which, as I mentioned earlier, you might take title as joint tenants or jointly with someone else. But it really matters how you took title for whether or not that property will properly pass to the survivor. The best way to make sure that you're shoring everything up is just to do a trust and to have very specific instructions in place about how those assets should be managed. And then for the second category, we have assets that would designate the living trust as the pay on death or transfer on death beneficiary. So for example, there's some assets like retirement accounts and life insurance policies that have to be in your name as an individual while you're alive. And so the only way to really make sure that those assets are properly going to be directed to a certain person is by beneficiary designation. Now, there's going to be some situations where you might not want to name a direct individual. For example, if you have a minor child or you have a beneficiary who is on public benefits, you don't want those funds to be directed straight to them if you were to pass away. And so a good alternative would be by naming your trust as the pay on death beneficiary for those funds if you were to pass away. When it comes to minors, for example, in California, and I would say in most states, probably in the US, minors can't receive funds directly. And so even though the intent may be that you want to provide for them, and if something happens to you, you want them to be supported, they can't actually legally claim those funds on their own. And so someone else would have to go to court in order to be formally appointed to manage that money for them. A way to get around that, just do a trust, and then you can have really specific instructions in place about who manages those funds and how and when that minor should receive the funds. And same thing for any people who are on public benefits. You may not want them to inherit a large chunk of cash or assets that would potentially disqualify them for receiving those public benefits. And so a better way to do that would be by directing those funds through a trust. There's always going to be pros and cons to naming a trust as a beneficiary for certain assets. So it's really important that you at least talk to an attorney or get some advice about what the pros and cons are there. But as far as avoiding the probate court, you may want to consider naming a trust as a beneficiary. All right, so now we're going to talk about last wills and testaments, which I think is probably the document that most people are going to be familiar with when they think about estate planning. For our purposes today, I'm really going to be talking about two categories of wills. The first is a standalone last will and testament. So that type of will, you're assuming that you have no trust that you've created, and that document is what you're going to be primarily focusing on as far as leaving all of your instructions in place. So you get to identify who's going to be in charge of that will, so that would be your executor, and ultimately where you want those assets to go. Now, with a standalone last will and testament, depending on the types of assets that you do have that you'll be transferring to beneficiaries through the will's instructions, you're likely going to have to need to use the probate court process in order to do that. Whereas if you're considering a pour-over last will and testament, that's going to be created in the context of a living trust. And really the pour-over last will and testament just serves as a backup document to the trust for any assets that weren't properly funded or connected in any way to the living trust at the time of your passing. So I think the most common misconception that I hear from a lot of prospective clients or people that I talk to when I do these seminars is, that having a last will and testament is all you really need for estate planning purposes, and that it would avoid probate. And that's not necessarily the case. So what a lot of people don't know is that California does have a threshold value for assets that may be left in just your name upon your passing that would require the probate court system in order for those assets to pass to your heirs or your intended heirs. That number is a very specific number, so it's $166,250 in value. I'd say for most people in California and in the area that we live in, most real estate, or if you have a primary residence, that's going to be enough to push you over the threshold to require a trust or to consider an alternative to just doing a last will and testament. But I don't know if anyone here who's tuning in or if our in-audience participant has had to go through probate before. It is not the smoothest process. It's not the fastest process. And so for the most part, what we're trying to do with all of these different estate planning documents is to minimize your exposure to having to deal with the probate court or to help you avoid it altogether. So really, what is probate court, right? So like I said, for any individuals who either don't have any estate planning documents at all or insufficient ones, like let's say they just do a last will and testament, right? And they pass away and they're at that threshold amount or greater than that threshold value that I mentioned, then you have to deal with the probate court because they will oversee the administration of your estate, which can be a very lengthy process. I practice in most counties in Northern California, but on average, a normal probate takes about a year to 2 years to complete. And what that really means is that your heirs can't receive or typically won't receive any of their inheritance until the very end of that 1 to 2 year period, which requires multiple hearings and a lot of procedural steps. It also can be very expensive. So aside from just the regular attorney's fees and executors or administrators' fees, there's also going to be various miscellaneous court fees and other third parties who are entitled to payment through the process. So for most people, I estimate just out-of-pocket costs from start to finish, you want to expect to spend at a minimum $1,500 to $2,000 just on those miscellaneous court fees and other third-party fees. And then the attorney's fees themselves are based on a statutory scheme. So it's all going to be based off of what the fair market value of all the assets are that have to go through probate. So for example, if you have a primary residence that was really your main asset, but it was left in your name individually, and you either had no estate planning documents at all or just a last will and testament. And let's assume that that property is worth $300,000. The probate court doesn't care if you have a $200,000 loan on that property. They're going to treat it as if that property is worth $300,000 when they're calculating all of the attorney's fees for that. And so without boring you into the minutia of how to calculate the fees, if it was about $300,000, you're looking at about $9,000 in just attorney's fees. And the executor or the administrator who has been appointed to oversee and administer your estate, they are also entitled to that exact same fee. So for just your primary residence that may be worth fair market value, $300,000, you're looking at somewhere between $9,000 to $18,000 just in statutory fees to the attorney and or the executor or administrator to get that probate done. It's also a public forum. So whenever you're dealing with the probate court, anyone can tune in. Most courts in California nowadays, especially due to COVID, have moved to either a telephonic or a Zoom appearance system. Or if you were just really curious, you could also just show up at the courthouse on the day of a hearing and sit and just watch all of the different cases that are being heard. Very few matters are private, and so just know that if you do have to deal with the probate court system, it is going to be public, and most of the documents that are filed are also part of the public record. So anything that you file, for the most part, is something that can be accessed or downloaded by anyone of the general public. All right. So inevitably then, the next question that I get is, okay, so we've talked about a living trust, we've talked about these different types of wills. What is the actual difference between these documents? And so when it comes to a will, you're likely going to need to deal with probate, right? If you meet or you're over that $166,250 threshold. And then especially also if there's any real estate. I mean, you're probably dealing with the probate court if that's the case. And if you have a will, it's a public forum. And the other big difference is that it's only effective upon your passing. So if you only have a will and that's your only estate planning document that you've put in place, it's not going to serve you at all during your lifetime if you ever become incapacitated, because all the provisions pretty much only provide for administration of assets after you've passed away. Whereas with a trust or a living trust, it doesn't require probate necessarily, as long as you've properly funded all of your assets into the trust and that you've been diligent throughout your lifetime in making sure that those assets are funded into the trust upon your passing. It can be privately administered. So a lot of people ask me, well, who oversees the trustee, right? I might appoint my sibling or my child to be the one to manage this trust, but who are they accountable to? And really the answer is, they're accountable to the beneficiaries, but there's no court that's overseeing any of that administration, which generally speaking makes it much simpler and more streamlined to administer. And that's assuming, though, that no one is fighting. Anytime the gloves come off and beneficiaries start fighting, you're probably looking at a longer time frame in which you'll have to administer any documents. And the biggest difference between the living trust and the will is that the living trust is going to be effective during your lifetime and after your passing. So I kind of like to tell clients that the day that they come back to sign their documents after we've put it all together into a draft that they're comfortable with, that's kind of like the birth date of the trust, and the trust itself starts acting for them right away. So whether they become incapacitated during lifetime, either temporarily or permanently, there are very specific instructions in place that also, through the trust being a key, will give their successors access and to use that trust as a key or a legal key in order to manage any of those assets that you've funded into the trust for your benefit throughout your lifetime, and then ultimately for the benefit of whoever your beneficiaries are upon passing. All right. So that covers wills and trusts. I'll definitely be answering any questions that you have at the end of the presentation, but now I'm going to move on to durable power of attorney for finances, and it covers some other personal affairs as well. But essentially, when we're talking about a power of attorney, that's going to be an agency document. So what you're doing is you are appointing an agent to basically step into your shoes and, for all intents and purposes, act as if they were you during your lifetime. And that can be effective either immediately or only if your doctor has deemed you incapacitated. Lots of different durable powers of attorney will have different provisions for what the definition of incapacity is. So it's really important that if you're someone who's been named in a power of attorney as an agent, that you look really carefully about what the triggering language is for you to be able to step in and assist the person who's created that document. But generally speaking, the durable power of attorney really is just meant to supplement the living trust during your lifetime, so that any of those assets that you can't immediately fund into the trust, like the retirement accounts or life insurance policies, those can be managed for you if you ever can't manage them yourself. And it also encompasses kind of, things like dealing with taxes or insurance or bills, kind of generally things like that. And so I think a really good rule of thumb is, if you're going to be designating someone as your agent, that you really want to make sure that they understand what your financial life is like, or have the capability to step in and dig through and put together what your full financial life looks like, because they're really stepping in and acting as if they are you to maintain everything for you for the rest of your lifetime. All right, and then the Advanced Healthcare Directive is basically your power of attorney for healthcare purposes. So again, it's an agency document, and I would argue that the Healthcare Directive's primary purpose and most important purpose is identifying who can make those medical decisions for you if you're not able to do that yourself. So you basically get to decide, here's this person who I trust, who understands what my wishes would be if I verbally cannot tell my physician or healthcare providers what my preferences are regarding treatment or withholding of treatment. You can get really specific with your healthcare document if you want to, as far as what your end-of-life preferences are regarding whether it's choice not to prolong life or choice to prolong life. We can incorporate lots of other preferences regarding types of medication that you may or may not want to be administered. But overall, again, the most important piece of that healthcare directive is that you're identifying who can make medical decisions for you. Now, if you didn't have either the durable power of attorney for finances or the advanced healthcare directive in place, and if you became incapacitated and couldn't tell your doctors what you want, or you couldn't deal with your retirement accounts on your own, then no one else really has authority to do that on your behalf. And the alternative to that is the big bad probate court, which is basically the venue or the entity that would oversee anyone else stepping in and formally managing those items for you. So really the benefit when you're thinking about all these different estate planning documents and putting them in place is that you get to dictate who those very important people are going to be, who would be following your instructions. And then you also get to dictate how things should be managed either during your lifetime or after you pass. Otherwise, you've got the court involved, and I don't know if anyone tuning in has followed the Britney Spears case or any of these other celebrity cases where someone has lost capacity and you hear that hundreds of thousands of dollars have been wasted away because they've had to go through what's called a conservatorship process. This type of document, or having these types of documents in place, are ways to avoid having to deal with the probate court and a potential conservatorship if you ever do become incapacitated. All right, so What are the benefits then of estate planning? Primary benefit is going to be avoiding the probate court system. You also get some ease of administration of your affairs according to your wishes. So you get that control. And personally, as a control freak, I love that idea so that I get to dictate exactly how things should be handled. You also get the benefit of privacy, right? So if you have all of the appropriate documents in place and you've set them up correctly, then hopefully you shouldn't have to deal with the probate court system at all, and your affairs could be managed privately for you. And then also just efficiency. Anytime you're dealing with the probate court or having to go through any extra procedural steps related to the court system, you're always going to be beholden to either the procedural requirements of the court and or their calendar. So earlier in the presentation, I mentioned that I do practice in lots of different counties in California, and they all vary wildly as far as what their calendars look like. So for example, Sacramento County right now, if you wanted to get a hearing to start a probate proceeding, for the most part, you're looking at somewhere between 5 to 6 months out where you're in complete limbo and no one can be appointed until that date. In comparison to another county like Yolo County or Placer County, where it might just be somewhere around 2 to 3 months out. So if you want to avoid any potential efficiency issues, it is good to come up with these estate planning documents on your own. Okay. And then ultimately, who is estate planning appropriate for? At a minimum, every adult, so as long as you're age 18, it is important that you at least have a durable power of attorney for finances and an advanced healthcare directive so that you can avoid the Britney Spears situation and you don't have to deal with the probate court if you ever get in an accident or something happens where you just can't manage things anymore on your own. So again, you're the most important person when it comes to these documents. So at a very base minimum, making sure that you're supported during your lifetime is really important. And then a living trust itself is typically going to be very appropriate for individuals who have minor beneficiaries, beneficiaries who are not very good at managing money. So maybe you've got beneficiaries who like to gamble or have a lot of creditors issues. You may want to put a trust in place where somebody else is managing the money for them after your passing, and then you get to also decide how and when those beneficiaries can receive their shares. And then, like I talked about earlier, generally if you have an estate worth over $166,250 in value or any real estate, then considering a living trust may be a very good option for you regarding estate planning. There's always going to be some outlying situations where maybe a trust is not the most appropriate, even if you do have these types of assets. So it really depends on a case-by-case basis, but earlier on, I said that I'd talk about some things like joint ownership as a type of informal estate planning. For a lot of people who come to me, they will ask me a question like, well, I know that there's a type of ownership for real estate called joint tenancy, so how about I just put my kid on title with me, and would that avoid probate? And the answer to that is yes, that would avoid probate. However, you are potentially unknowingly triggering some negative effects of putting a child on title with you to real estate. So a trust may be a better alternative. Some examples of potential negatives if you do put someone on title to your real estate with you would be if they ever get in an accident or they owe someone else money, then it looks like they own that asset, and that person who's coming after them might try to come after that property now to seek repayment of whatever that debt is. Another potential issue is based on the current laws, there's what's called a step-up in tax basis for any real estate. And I don't mean to get too far in the weeds regarding taxes, but one potential benefit that you lose out on is that if someone is inheriting property, generally speaking, they'll receive a tax basis step up for that real estate, so that whatever the fair market value is of the property on your date of death, that's their new basis for calculating any capital gains if they were to sell that property later. Whereas if you put them on title with you right now, they don't get the benefit of that step up in tax basis. There's also been some changes recently regarding property taxes. I won't get too much into that, but with Prop 19, there's been some changes regarding parent to child or grandparent to grandchild transfers of real estate. Putting someone on title with you right now might also affect that, depending on whether or not that child plans on using that property as their primary residence. But it's completely on a case-by-case basis. So those are just some things that generally you'll want to think about. All right. And with that, that covers, just generally speaking, revocable living trusts, last wills and testament, durable power of attorney for finances, advanced healthcare directives, and then just some other things to think about regarding the way that you take title to assets or designate beneficiaries. So now I'd like to open it up to any questions. So I don't know, Gina, do you have any questions?
Not at the moment.
Okay, yeah, sounds good. Okay, let's see. Oh, okay, we do have a question. It says, if our checking account for my husband and me is titled in the trust, and then we both die in an accident, can one of our children or the successor trustee use the funds to pay for our final bills and current bills right away? Oh, perfect. Oh, sorry, yeah, perfect. So whoever you have designated as your successor trustee in that situation, they will need to have death certificates issued in order to be put onto those accounts as the successor. So typically, right, that'll take somewhere between 7 to 10 business days. But once they do have those death certificates, they can be put onto that account and handle any final burial costs or expenses. For the most part too, just in case there is some delay between when death certificates are issued and when your successor trustee, whether it's a child or someone else who needs to step in, right? If there's a delay or kind of a gap in that time frame, if that person is willing to front the cost, they can always reimburse themselves once they do get access to the trust funds. And generally speaking, the trust funds should be used for any final burial, cremation, anything related to like a service or a memorial, and then also, if there's like a obituary that's going to be put in the paper, kind of any of those final expenses should be properly paid for from the trust, or at least reimbursed if someone is paying or prepaying for them.
Couple of questions.
Okay.
So in amending the trust, so I had a trust drawn up about 10 years ago. You mentioned a document that you can add to anything. Would that be that document to make the changes on, or should I have a separate amendment to the trust? Or if I need to make changes, what do you recommend?
That's a really good question. So if you are going to be making any adjustments to the trust, it would be through a formal amendment. It's not self-serving when I say that you should use an attorney to do that, but I do highly recommend that you use an attorney just because the trust is a legal document, so your trust will also have a very specific procedure for which you're supposed to do the amendment. So you want to make sure that those amendments or those changes are done properly.
And then I had a question on the bank accounts. You mentioned funding. They do ask for a beneficiary. So if you don't have a living trust, would the beneficiaries have a difficult time getting a hold of the funds upon your death with just the death certificate?
No, so if you don't have a trust and you just designate a direct person, as long as they have the death certificate, then they would be able to just put in a claim for whatever those funds are. So if you have just like one person who's the beneficiary, then they're really the only one who the bank would even talk to. They wouldn't speak with anyone else other than the designated beneficiary.
But you do recommend that the bank accounts be under the living trust if we have a living trust already, from what I understand you're saying?
Yeah, so normally with bank accounts, you can either fund them by currently titling them in the name of the trust, and that's typically done by making an appointment with the bank and completing what's called a certification of trust or a certificate of trust with them. Or if you've got a lot of direct deposits and automatic payments that are coming in and out of those accounts, I don't necessarily want to disturb that for you because sometimes the bank will make you close those accounts and reopen them if you're going to be retitling them into the name of the trust. So if you do have a lot of those types of transactions coming in and out regularly, you may just want to designate the trust as the pay on death beneficiary instead.
Then I had one last question. When the trust is drawn up, does the county have a copy of the trust, or do we just have our hard copy and that's it?
Yeah, that's such a good question. So, because it's a private legal document, you are the only one who really has the document. Right after it's executed, you don't lodge it anywhere. You don't, record the full document with the county. The court doesn't get it. So it is important that you not only have your hard copy, but I highly recommend that you also just scan it in and keep it in a digital format somewhere. If just in case the original gets lost or destroyed, as long as you do have a digital copy or a copy somewhere out there, the trust is still valid, so it will still continue to be effective.
Super, thank you.
Mm-hmm.
I think that was it on my part.
Okay, sounds good.
You.
Thank you. Okay, so next question is a text question. So it says, why is it that when a person gets dementia, I think I just lost it. Oh, there we go. Why is it that when a person gets dementia, the lawyer recommends adding a successor trustee as a trustee? Why doesn't the durable power of attorney work? That's a good question too. So if we think about it as in terms of funding, right, I think that's probably going to be the best way to consider it. So if the person who created the trust is still alive, but they become incapacitated, or maybe it's early onset, dementia, their attorney may recommend considering putting someone on as a current co-trustee with them to have immediate access to any trust assets. So that's kind of that one category of assets, right? The funded assets into the trust. Whereas the durable power of attorney is going to cover a separate category of assets, which would be anything that's still in the name of the person who created the trust, but it's in their individual name because they're still alive. So kind of like those retirement accounts or life insurance benefits, retirement benefits or life insurance policies, or dealing with things like filing taxes. So each of those documents serves really specific but distinct purposes. So it may be appropriate or even necessary to add somebody onto the trust right away, even though the power of attorney is also in place.
Okay, this is Linda. I've unmuted myself. Can you hear me?
Yes.
Okay. So let's say if something sudden happens and there isn't any time to like in my case, my parents were still able to sign documents, but I could see that mentally they're having a lot of problems handling their money. But let's say if something like someone got in a car accident and something happened, then what do you do with the stuff in the trust unless you plan for like 10 years earlier to put your kids or someone's name on there as a trustee, and when you're still like able-bodied. So I mean, how do people plan for that?
Yeah, so there's always going to be an incapacity provision in the trust, and that can either be a temporary or a permanent incapacity. In the hypothetical that you're presenting where there's a car accident, maybe you are, mentally capable, or maybe not mentally capable but physically capable, whoever you've already designated as your successor trustee, let's assume it's kids, all they need is a physician statement or potentially two physician statements depending on the way that the trust was set up, just saying that you are not able to manage your own finances currently and that you need someone to step in. And then that gives your successor trustee the ability to step in for you. So there's always going to be these triggering events that are provided for either during lifetime or after you've passed.
So when the physician writes these statements, is there some legal document that then you can present to the banks that have an account with the that have the account that's under the trust?
Yeah, so
usually you have to present them some kind of legal document.
Yes. Earlier, when I was talking about funding of trust, I mentioned a certificate of trust. The same type of document, basically you're certifying that you as the successor, if you're the successor trustee, right, you're certifying that you have met whatever the criteria is in the trust to trigger your ability to step in and act as the successor trustee. So in the case of incapacity, the doctor would typically on their own letterhead write something like, Alyssa Chow, it's my professional opinion that Alyssa Chow lacks the ability to manage her own finances or healthcare, right? Then you would just attach that statement to a certificate of trust and present that along with potentially a full copy of the trust to the bank to be put on as the successor trustee. Again, it kind of depends on what the triggering factors or triggering events are that the trust provides for, because some trusts also provide for like a disability panel where there's other individuals who also have to weigh in other than a physician. But let's just assume it's just one physician statement required. Yeah, all you would have to do is just get that that statement from the doctor, attach it to the certificate, and present it to the bank.
Okay.
All right, next question is, do we give our durable power of attorney or healthcare directive to our children, to our doctors, or to whom do those documents go to or just sit in our home? Also a really good question. So all of the documents are yours to do with as you wish. For healthcare directives, I generally make copies for clients and direct them to give them to their healthcare providers the next time they see them so that it can be placed in your medical record. That way, if anything happens, it's already part of the record and they know exactly who your agents are. As far as power of attorney for finances, it's up to you whether or not you want to give copies of those to the agents that you've designated. It can be a little bit of an awkward conversation if you do decide to make changes to that in the future and you've already given a copy to someone that you've later taken out as your agent. So in the alternative, if you don't really want to immediately give copies to people, I do generally just recommend telling your agent that you've created a document naming them and letting them know generally where they could find that document if the situation were to arise where they needed to step in. Okay. The next question was, there was mention of putting stocks or bonds in the living trust. Does this mean IRA? So when I talk about stocks or bonds, I mean just individual stocks or bonds. So there might be something like, nowadays most people have like a computer share account where they might have computer shares, the transfer agent managing any dividends for stocks that they might have. So those types of accounts or those stocks are ones that I recommend being in the name of the trust. IRAs are individual retirement accounts. Those ones can't be retitled into the name of the trust. So that type of account might have different funds or bonds within the IRA, but the IRA overall would just stay in your name individually. So when I talk about stocks and bonds, I really mean just standalone on their own and not under the umbrella of a retirement account. Okay. Any other questions? All right, let's see. Okay.
Yeah.
Okay. Oh.
We had a question. Sorry, Elizabeth.
Okay, there we go. Yeah?
So if you have all your financial assets, whether they are your retirement accounts, bank accounts, securities accounts, with a beneficiary, and your retirement accounts have contingent beneficiaries, and your property now, I believe in California, you're kind of a TOD, right? So you're not putting your beneficiary on your title, but it's a transfer on death. And obviously these assets exceed 166,250, then would it still go through probate?
So generally speaking, yeah, generally speaking, as long as you have a direct beneficiary for assets, any of those funds or assets that do have a direct beneficiary, it's like estate planning in and of itself, right? So really, whoever that beneficiary is the legal owner upon your passing of those assets. So they wouldn't or shouldn't have to go through probate. The only time where the probate court might have to get involved is if there's some issue with the way that the beneficiary designation was set up, or if you might be thought that you set up the beneficiary, but it got rejected and it was never corrected. I've actually had to deal with a couple of probates like that before with like life insurance policies. So, but generally speaking, yeah, as long as you have direct beneficiaries on those assets, they shouldn't have to go through probate and wouldn't be calculated into the 166,250. When it comes to the, go ahead.
Property? Sorry, including property. Now California allows a TOD on property too, right?
Yeah, I was just going to mention that. So there is this thing called a revocable transfer on death deed. I personally don't advise on those just because It's kind of like an experiment that the legislature is trying right now. It's been a couple years since they've enacted it, where you can basically designate a direct beneficiary on like a piece of real estate. But there's a lot of limitations to that. And it essentially, from what my understanding is, and I don't want to dig myself in too much of a hole since I don't generally give advice on those types of deeds. But for the most part, the best case scenario for those types of deeds is if it's an individual person transferring to another adult individual person. There's some limitations regarding, you definitely don't want to name minors as the TOD beneficiary, and it has to be an identifiable person. You can't generally say to my children or something like that. But yeah, as long as it meets the exact criteria of execution of a proper TOD deed, then whoever the beneficiary is should be able to own that asset upon your passing.
Thank you.
I just had one more question. If you have foreign assets like property or financial assets in another country, how does it work with the revocable trust?
So unfortunately, the trust itself only can control assets that are located in the United States. So whatever assets you have or might have in a foreign country, those assets are going to be subject to the laws of that country. So you'll have to meet with an attorney or someone there to
So we'd
assist.
have to have two different things in two different countries.
Yeah, it doesn't hurt to at least reference the foreign assets in your own trust, but there's really no formal authority for your trustee to do anything with those assets. And so it's best if you speak with somebody or an attorney out in that country.
Great. Thank you.
You mentioned the stocks, individual stocks, and what is the form that you complete, or how are you able to place those stocks into the trust?
So if you've got like a transfer agent, then you would just contact the transfer agent and let them know that you want to retitle the stocks into the name of the trust or the account with the transfer agent. Otherwise, with the stock itself, there's usually some language on the back of the stock regarding transfer, and you would basically just transfer your ownership into the name of the trust, and they would reissue you a new stock certificate with the name of the trust as the owner.
Thank you.
Okay, now, okay. Any other questions, Sean? Yeah. Okay, we've got one coming up. Okay, so it says, my husband and I have a living trust. My husband passed away. Do I need to redo the living trust? That's a good question too. And I'm going to give you the most attorney response, which is it depends. It depends on the way that the trust was set up. If it's a really general kind of the simplest form of trust, you really shouldn't have to do too much other than I typically recommend evaluating or reevaluating what all of your assets are, just to make sure that everything is properly funded into the trust. And anything where your husband may have been listed as a current co-trustee, you'll probably want to remove his name just so that it shows that you're the only surviving trustee, if that's what the trust allows for. So it's a good idea to maybe meet with an attorney just to review the terms of the trust and make sure that there's not too many steps that you need to take. But I'm really sorry for your loss. Okay. Well, with that in mind, that concludes my presentation for today. If anyone has any questions, feel free to reach out. ACC has my contact information, so I am offering free consultations for anyone who tuned in today. And be sure to also tune in later for ACC's Big Day of Giving, which is coming up. They're doing their telethon on May 4th and May 5th. Thanks again.
Thank you.
Thank you.
Thank you. And thanks for